During a pretrial settlement conference, what is the likelihood that you'll be able to speak to the judge who's supervising these settlement discussions? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now, as your case gets up to the point of trial, we're going to have pretrial settlement discussions. I may call you into court because I want you there with me in the event the defense actually makes an offer. I want to be able to speak to you about it and discuss with you the risks and benefits of accepting or rejecting an offer. There may be certain instances where you turn around and say, hey, I want to speak to the judge before I decide to either accept or reject an offer. How likely is it that you'll be able to speak to the judge who's supervising these settlement discussions? The answer is, you might not be able to. On the other hand, there may be some instances where the judge will agree to speak to you. And there are many different reasons why the judge will not speak to the injured victim. If I think that the client speaking to the judge is going to be a key component of getting the client to either agree or disagree with the settlement offer, then I'm going to go back to the judge and explain why I believe it's important that the judge speaks to my client. In some limited instances, the court will go ahead and allow us to go in and speak to the judge. Now, when that happens, the judge is going to be very straightforward and very blunt with the injured victim. And the judge will come right out and say, listen, in this court, in this venue, in this type of case, here's what I have seen in the past. And if you do not accept this settlement, there's a very good likelihood you could lose your case. Now, you may win this case, but now you'll wind up going on appeal and it'll take you many years to get an ultimate decision. On the other hand, the judge may tell them, listen, I think I can get you a little bit more money. I'm going to speak to the defense attorney and then bring you back in. And now the defense attorney is going to come in, the judge will speak to them, see whether or not there's the possibility to try and obtain additional money to compensate them. And if there is or isn't, now the judge will bring us back in and let us know whether he's been successful or not. But in the majority of cases, the judge will not want to speak to the litigant. It is my job as the attorney who represents the injured victim to explain to you the risks and benefits of any proposed offer. And the judge is there to put pressure on the defense as well as on us to try and reach a negotiated settlement prior to going to trial. If we can't reach an agreement, then the judge will simply give us a trial date and now we go forward with trial. So why do I share this quick information with you? I share it with you to give you an insight and an understanding into what goes on in the litigation process, especially as your case is coming up for trial. You know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.